I'll just like to introduce, first of all, Seth Goldsamt, who is the chairman of the Danish-American Chamber of Commerce and who will take it from here. Thanks, Seth.
Thank you, Christian. Hi, I'm Seth Goldsamt, the chairman of the board of the Danish-American Chamber of Commerce, New York. Also a partner at the McGuire-Woods Law Firm in New York. I would like to welcome you to the Danish-American Chamber of Commerce webinar on Post-Inauguration Perspectives on U.S. Immigration for Danish Companies and Individuals with our host, Steve Maggi. Danish-American Chamber of Commerce is a non-profit corporation established to help promote trade relations between Denmark and the United States. This year, we are proud to be celebrating our 90th anniversary. If you are a DACC member, we thank you for your support. And if you are not yet a member, we welcome you to become a member. Please visit us at our website at daccny.com, where you will see a long and impressive list of member benefits and promotional opportunities. Before we get going with Steve, a few housekeeping items. Attendees should submit questions through the Q&A button at the bottom of the screen, not the chat function. So please use the Q&A button with questions, and we'll try to get to those during the course of the webinar. Another note, Steve has agreed to provide 15-minute private one-on-one consultations to the extent you have questions that don't get addressed during the webinar. So you should feel free to reach out to Steve directly, and if you need his contact information, please contact us at the Chamber. A video of the webinar from today will be made available at our website. And then before we get started, I would like to do a quick promotional message for our next event, which will be a virtual wine tasting where we will taste wines from the Ravines wine cellars of the Finger Lakes in upstate New York. The event will feature the Ravines founder and winemaker, Morten Hallgren. And who knew Danes could make wine? Well, to find out, please join our event. You can find the link and how to sign up at our webpage. The event will be March 18th at 5:30 p.m. And now let's start with our program. Let me tell you a quick blurb about Steve. Steve Maggi is the founder of the New York law firm SMA Immigration and Consular Law Attorneys. He has a long and successful track record of helping Danish and other non-US companies navigate the choppy and challenging waters of US immigration law. He's also a board member of our chamber. And without further ado, I'd like to introduce Steve Maggi. Steve?
Thank you, Seth. I appreciate the introduction. For those of you who don't know me, I'll give you just a background on me. I'm originally from Argentina, so I'm not Danish, please forgive me. But I came to the US when I was 5 years old. My mom was a US citizen, but she couldn't sponsor me for a passport because she hadn't lived in the US as an adult. Her parents were Hungarian, and my father's family was Argentinian, Cuban, Spanish, Italian. So I went through a 9-year process to eventually become a US citizen when I came here. And that's what made me understand what it feels like to go through these very complicated and complex and really incomprehensible processes sometimes when you're going through this US immigration system. And that's what made me gravitate to becoming an immigration attorney. I've been lucky enough to be working with Danish companies for about the last 7 years since I set up in New York, and it's been a wonderful experience. I'm made to feel like I'm one of the gang, even though I'm not Danish, and I've had some wonderful times in Denmark and presenting there as well. So it's an honor to be asked to do this, And this is a very complicated time in immigration, more complicated than has ever happened in the last century. And so I'm happy to navigate a little bit with you what these waters look like and to give you an idea of where we stand and maybe what might be coming that will affect you as Danish employers, company owners, or just individuals. So I'm going to share my screen here, and hopefully everybody can see. Okay, so if this is what you feel like right now when it comes to your specific immigration issues and the strategies that you cannot implement because of all the issues during COVID, then you're not alone. I always said that the immigration system is...
Steve, sorry, can I just interrupt? Can I just launch the poll first?
Oh, yes, sorry about that.
Sorry, we have a poll that we just need to launch before Steve
Should I stop share?
Yeah, that would be great.
Okay, sorry about that. Should I get started? Thanks for your answers. I see that there's a general split there between the main two categories, which were L1 and E2, which is great because those are the visas that I'll be talking about specifically. So I use this as a metaphor for what it's like to navigate immigration right now, and it's very accurate. We've always had traditionally the three-headed monster, which is Customs and Border Protection when you try to enter the US that can stop you from entering. We have Immigration Service in the US, which processes all the immigration petitions within the United States, including a change of status or an extension or a green card petition. And then we have the embassies, which are under Department of State. And now what we've had in recent years is the executive branch, which also passes a lot of what I call executive legislation through executive actions, which have a huge effect on immigration. And we'll see some of those and the effects that they have. And then on top of all this, we have COVID-19, which leads to specific health-related policies that also stop immigration coming in and coming out of the United States. So we're going to address all those. So let's talk about the current state of immigration. First of all, it's important to understand that the Trump administration made about 400 modifications to the application of the law and immigration policies in 4 years through executive action, not through congressional change. And President Biden's job now is to begin to undo a lot of those policies. As many of you know, Denmark is included in the list of countries that have what's called a direct entry ban. That was instituted by President Trump and it actually is still in place. And there's no end date in place for that. And that's due to COVID. There is a bar on the issuance of specific visas, immigrant visas, which are for permanent green cards, as well as L1, H1B, and J1 visas. And that's in place until March 31st or until President Biden revokes it. Obviously, we're all hopeful of that, but that really is based more on COVID now than it was. When it was issued, went into effect under President Trump, it was about supposed job protection for Americans. USCIS, which governs all the petitions filed within the United States, is continuing to function and accept applications. This is very important. It has not ceased to function at any time. And so it's important to keep that in mind when you're in the US. And I'm going to separate my presentation between in the US and outside the US and what the different ramifications are of this. So it's important to understand that they are still functioning. And so you need to take advantage of that if you're in the US. DACA, which we won't talk about, is being reinstituted. So if you know of anyone who came to the US as a small child without inspection or whose visa ran out, they will have access now to protection from deportation as well as the ability to work. Naturalization process and what's something called the public charge rule are now being reevaluated. And this is great news for any of you Danes who are in the US who are thinking of applying for citizenship. This public charge rule, which went into effect in February of last year, was a way for the Trump administration to deter people from applying if they had ever applied for public benefits or if there was a chance that they might. And I think that that's going to be revoked. So there should be no issues now in going ahead and applying for citizenship. And then lastly, the comprehensive immigration reform, which is the big question mark here. Will that happen or not? So if there's anyone here from Denmark who is a DACA recipient, probably not agricultural workers, but you never know. And then obviously anybody who's out of status, this would require congressional approval. And I think that we don't know what the probabilities are, but I think the greatest probability is that DACA recipients will be given a path to citizenship sooner than later. So let's jump into the scenario if you're in the United States. So we're going to go from the least to most resistant path. And the one that provides the least resistance now is if you're already here. The next one is if you're outside the US but already hold a work visa, and you can access what's called the national interest exception, which I'm going to talk about. And then you have people who are outside the US who have active ESTA status. So that also, you can also apply for a national interest exception. And then lastly, those who are really at the bottom of the ladder here, which is the people that might have an approved petition, they might have a pending appointment in the embassy, or they may not have an appointment at all. And that is definitely the most complicated. If you have nothing in place, is the last one, is the most resistance, because there are so many different levels. And so we're going to try to figure out what the best strategies are based on which situation you're in. So let's start with the people in the United States. The mantra here is, when in doubt, don't go out. It's important to maintain your status at all time. And there's something called the I-94, which is the determining document. So for example, you might have a 5-year E2 visa, but when you enter the US, you're given 2 years of authorized stay. And then you have to either
We seem to have some trouble with Steve's audio feed.
most recent
There we
entry,
go.
and there they will tell you what your date is, what your end date is for your current status. That's the determining document, not what it says on your visa, but what it says on your I-94. So you need to keep that in mind, and you're going to have to extend your status if that's close to expiring. So like I said, always apply for an extension of status before expiration. If you're in an adjustment of status process, that means you're going for eventual permanent residence based on employer sponsorship. You also have to maintain underlying status. So in previous administrations, you were allowed to let your status lapse. Let's say you're here on an L1 and you have a pending adjustment process started. You were allowed to remain in the US until that process was over and you were here legally. But the rule of thumb now is to maintain your underlying status, which means continuing to extend whatever status you're in. ESTA holders are supposedly given a 30-day grace period. So if you entered the US, on top of your 90 days, you're given 30 days additional time. But what I always say is to be on the safe side. If you don't have to remain in the US, then you should go at the end of your 90-day period. Why should you be worried about maintaining legal status? Well, there's something called the ULP, or unlawful presence bar, that may come into play. And that means that when you leave the US, you may not be able to come in either for 3 years or for 10 years, depending on how long you've overstayed. So between 180 and 365 days, you have a 3-year bar, and over 365 days, you have a 10-year bar. So when in doubt, you want to be careful. If you can stay and extend your status, you should. But if you become unlawfully present, then you should try to leave the US as soon as possible. And do not rely on COVID as an excuse for overstaying. The US government can look at the policies of your home country and determine at the time that your time expired, your authorized stay expired, if you really were able to leave. And most people were actually able to re-enter their home countries, being citizens of those countries. So do not rely on that as an excuse, or you could accrue unlawful presence. How about employers? We have some people here attending certainly that are employing Danes and foreign nationals. So what are the basics here during COVID? We talked about employers. So there are approximately 1.5 million people who are working, being trained, or interning for US sponsors right now. So there's a lot of people that are involved in this. And the bright line rule is that you have to maintain their status, and that's directly tied to their employment status. So no job essentially means no status. And your goal should be to maintain their status, because once they've fallen out of status and they need to leave the US, it's going to be much more difficult, as you'll see coming up, to get them back in. If they are terminated, they begin to accrue unlawful presence. And there's only one exception really, which is the H-1B visa, where you have a 60-day window to change employers. So what are some of the alternatives here? One of them, if you're an H-1B employer, is part-time employment. You can do what's called an amended petition to shift them to part-time, and that can be all the way down to 15 hours per week, as opposed to 35 or more. If you fire an H-1B employee, they do have a 60-day window to find another employer, but we suggest that you stretch out their payment of their final pay stubs so they have more time to look, because it's a very difficult job market right now. For those of you who might have lost your job or might lose your job who are on H-1B, if you do leave, you have 1 year to reactivate H-1B through another sponsor, and you're exempt from the H-1B lottery. This is important because the H-1B lottery will be starting March 1st or next month. So right now, H-1B visas are not being issued outside the US until at least March 31st. So if you are sponsoring someone, either now coming up in April after the lottery, or as a transfer, you want to make sure that you're doing it within the United States as a change of status. If you designate it as consular processing, they might not be able to get their visa for many months. So what are some alternatives? Well, the law doesn't say whether furloughs, for example, apply to foreign employees. If they're designated or deemed as an equivalent to being fired, then that person is out of status. So the question is, what can you do in practice? Is there no harm, no foul here? And what I say is that you should utilize paid sick leave, vacation time, personal days, whatever you can to stretch things out. In many cases, you can go part-time because in practice, there are no checks on salaries until an extension is requested. So as long as you're showing that they're back on full pay before you go for an extension of their work status, you should be fine. But do not take them off payroll completely. I've had this question come up a lot, so I thought I'd talk about it just real quick, is what do the regulations say about physical work location? So some of these visa categories that you see up here are not location specific. And so there's complete flexibility in terms of working from home. And that's even if they're working abroad. If you have an L1 or an E2 employee, for example, that's overseas and was stuck there because of COVID, they can, if they want to, if you don't want to try to bring them back, they can work remotely as long as they're continuing to be paid on the US company payroll. As long as they are working in the same position and performing the same duties, there's no amended petition required. And the thing with H-1B is where it gets a little thorny, is that they're not supposed to work off-site. They need to stay within their outside commuting area. But as I said earlier, the caveat is here that there's no precedent for this now, and so there's no proactive requirement to report this either. So if you need to have them working remotely for now, it's fine. What happens if you absolutely can't retain an employee? Well, it's different for different kinds of visas. So the first one is H-1B. You have to notify USCIS and Department of Labor. That's what's called a bona fide termination. For these other visas that you see here, R, L, P, and O, you should send a sponsorship withdrawal letter to USCIS with the case receipt number. And for E2, E1, J, and M, you need to contact the embassy. So in this case, Copenhagen, US Embassy in Copenhagen, to let them know that you are withdrawing sponsorship. Otherwise, they're going to be in limbo. What are the keys to staying in the US legally? Number one, maintaining status, making sure that you're doing that through an extension of status or a change of status petition. Those have to be filed and received before the expiration date of current status, which, as I said, is determined by the I-94. A labor certification, if you're going through a sponsorship of an employee, that does not stop the clock in any way for them to extend their status. It doesn't serve as a way to keep them in status. And as I mentioned before, if you're going to let them go as an H-1B sponsor, then let them have the time to use that 60-day window. The most important thing here is to try to keep them on payroll, even if it's to a lower amount than what was originally planned. So let's shift to the second part. And this is the part where it really gets interesting and also complex, is if you're outside the US and you want to come in, what are the solutions? So let's talk about logistics first. There's a physical direct entry bar, there's a bar on specific visas, and then there are additional COVID-19 restrictions. As I mentioned, there's no direct entry from Denmark right now to the US. So what are the options? The first one is what my clients did until this exception that I'm going to talk about, the national interest exception, existed, which was the middle of June, was they would triangulate through a third country. So a lot of people go through the Caribbean or Mexico. So I would only say that this is recommended if there's no way that you can access the national interest exception. This one, the national interest exception, when it came out, it said specifically that they assume that if you are in any of these categories that you will automatically qualify. You still have to go through the process of applying, and we're going to go through the mechanics of that. But if you're F1, M1, you're a researcher, like a scientific researcher, or working in medicine, and you're in a J1 program, you're an investor or a business traveler, or you're an EB5 investor, then you should qualify for a national interest exception. Who else qualifies? Well, here you have all the people that could potentially qualify. And this is coming straight from Department of State. You'll see coming up that now the US Embassy in Copenhagen is only processing these student visas for now. And that's because of COVID. So this is the list of people. But the most important thing is what I've highlighted on the bottom, is that you need to show that you are doing it for economic reasons. And that means that every argument you make when you present one of these applications is based on the benefit to the United States. That's always my platform and my foundation for argumenting or for presenting any cases. This will benefit the US, and you show how. And once you've done that, it should be approved. So here's an example, the L1. I know we have some people watching that are on L1s. So how does one qualify for a national interest exception? Number one, and I'll say this a few times, is you already need to have your visa when you apply for this, right? Or ESTA, but we're going to talk about L1. So you need to qualify in two of these three categories. And generally, you're going to be a senior level executive or manager if you're in L1A. By definition, you have to be one or the other. So that's the first one. And the second one, it says, has spent multiple years with the company overseas. Now, the real requirement is at least one continuous year in the past 3 years as an executive or manager for the foreign company. But you should always, when you make these presentations, use the third argument, which is the key, right? That you are filling a critical need, and that it has to do with the infrastructure or the operations of your company. If you can show that you're essential to the US company's operations, and you want to make sure you communicate that via the job creation, job maintenance, and what will generate revenue. Those are the most important things. So it's very plausible, and we've done a lot of them for our Danish clients as well as other companies in other places for L1s, but you need to keep these requirements in mind. And when you do this, if you're doing it without an attorney, then you want to make sure you have a cover letter that uses these points and specifically mentions them in order to get the exception approved. So let's go through the mechanics here. How do I apply for a national interest exception? First of all, it has to be done for anyone who has a visa currently or is an ESTA holder. If you're not an ESTA holder, you can apply now, and then you can use it. They're all submitted via email. So what we do for our clients is we include a cover letter and all supporting docs in one PDF. We attach that to this, and then we put in the subject line, NIE request for, and the name. This is for Danish nationals that are currently in Denmark. So companies requesting these on behalf of multiple employees should send each request separately. So we've done a case for a company that needed to bring in 6 of their employees that were overseas, and we were able to do it, but we did it one at a time. Attorneys can represent you in this process. What I do is consular work, so that's a lot of what I do, and all you need to do is fill out one form, which is called the G28, in order to enable them to give a legal cover letter as well and present all the documents on your behalf. So I talked about what the cover letter is. That's, to me, the most important document because it points you in the direction not only of the documents that you're using to support the case, but also what the applicable qualifying factors are. And so you want to use the language, as I said before, that directly is related to your case. And that really is national interest for economic reasons. That's why I've highlighted that. So that's the most important take home here. Now, you can qualify as an E2 or an L1 applying those criteria. So like I said, E2s, they are already assuming that you qualify if you have an E2 visa, but you still want to present the arguments that you need to. Now, here's something that's interesting that some of you may not know. If you work for a Danish company now, and that company has been contracted to do work with the US companies that involve infrastructure, building, public works, construction, things that have to do with building the US economy, and you have a US economic interest, then you can also get a national interest exception without having any US visa. You can do it under ESTA. And so we did this for a Danish company which builds greenhouses in the Midwest. All the European-based employees were either working for the Danish company or for companies in other countries that were subcontracted by the Danish company. And what you need to show is the nexus, which means contract between the entities and the proof also of the specialized experience for each applicant. So that letter, the attorney letter, talks about why the person qualifies, and then you have a letter from the sponsor company in the US and the employer, in this case a Danish employer in Denmark, and that's part of your, so then you can bring employees that are working in Europe for special projects in the US. Applicants must be in Denmark when applying. So they will actually look at when the person is physically in the US or anywhere outside of Denmark. They'll know if you're in the United States, you cannot submit the application. So we usually submit them as soon as our clients arrive in Denmark. We submit them, and that allows them to get this NIE approval, which is good for only one entry and must be used within 30 days. If the employees need to return to Denmark, then you apply again. Obviously, the process is very quick. It takes about a week to get the approval, sometimes less. And if they have a previous NIE approval, then that makes the case even stronger. It should be approved even more quickly. There is a new wrinkle in this, is that you must get a COVID test and fill out an attestation to utilize it. So you can look that up online, but that's the new COVID requirement. I'm going to talk about that. Okay, so what about if you don't have a visa? And this is where it gets complicated. So all visas are not barred by the proclamations, but right now, a new wrinkle, and when I was talking to the board members, I was saying I will constantly have to update this presentation, and it's true because now the embassy website says as of the 11th that only F1 student interviews are being held. So it's very interesting because you don't know what the pecking order of the priorities are, and they're limited in staffing and they're backlogged. So the EU visa unit, I got an email back from them today confirming that they are still accepting petitions. They have been throughout in the entire time of COVID, but now interviews are on hold. So if you're looking to do an E2 and your petition is ready, or you're within a short amount of time of getting it ready, you want to submit it as soon as you can because that backlog is getting greater and greater. As some of you might know, that the process is already streamlined, and you have to, every page matters. There's a 50-page double-sided limit on E2 applications. So you want to make sure that you're always presenting the strongest case possible. So don't rush to submit until you have the case that is as strong as it can possibly be. Let's talk about the blanket bar on visas. And I know we had some questions come in before this event about this. So there are two what are called presidential proclamations. The first one suspended certain kinds of immigrant visas. And then there was another one that suspends H1 and L1 as well as J1. And that's a big problem here. I know the chamber also we were starting our J1 sponsorship program. There's a lot of companies, Danish companies, that use J1s, and so this is very problematic. People who are exempt from these proclamations obviously are US citizens, green card holders, and now people who already hold visas or are in the US in status. If any of you are waiting for an immigrant-based green card, these are the categories that are affected. And then the next question is, if it's not revoked and you have an approved USCIS petition, what can you do? So one workaround that we've been able to use for L1s is to use either ESTA for people who have ESTA or B1 visa, if you have that, to enter the United States as a representative of your foreign employer, because L1 requires foreign employment and you're still on the payroll because you don't have your visa yet to work in the US. You can come into the US either for 90 days under ESTA or under a B1 as a consultant, consulting with the US entity, but as a representative of the Danish company. Don't forget, you still need the national interest exception, but this has been a great workaround for some of our cases. And what we just did is we had a B1 that we presented as a change of status. So they were here 90 days. You have to avoid what's called the inference of previous intent. So once you're here 90 days, you can apply to change status. And now they're in L1 status in the US. Let's talk about the limited exception. I'm not going to read this whole thing, but we had a question about this and I wanted to point out that there's a specific exception to this bar on non-immigrant visas on the issuance of them. And that's because of this case that you see that was NAM versus Department of Homeland Security. So it says, in essence, that if you're a J1, H1, H2, or L1, and you're petitioned by any of these companies or organizations, or a member of those organizations, and this really applies to J1 principally, then you are exempt from this bar, which means you could be issued a visa if you have an approved petition. For J1s, you're applying directly at the embassy. But what's the problem? The alert is here, right? The problem is that that requires a personal interview, and only at the personal interview can you prove that he or she, or you in this case as the applicant, falls under this exception. And because the exception is very complicated, obviously you would want to use a consular attorney to present the case. But the problem is there are no interviews available right now. As I just mentioned, that became even more backlogged now because as of the 11th, the only visa that you can get an appointment for is F1. And what's on the website as a suggestion is that expedited appointments can be requested. But the caveat here is that they are not generally given unless it's for medical or humanitarian reasons. So for those of you who are waiting to bring in your J1s and they're a part of these organizations or members of these organizations, you still need to wait. You can attempt to do expedited, but it's probably going to be a while before you can actually process the J1s or any of these other visas. So because of pandemic restrictions, and I'm not an expert on Danish health laws, I'm sure some of our members would know much better than I do, but in response to the additional restrictions enacted by the Danish government, the US Embassy is essentially closed except for F1 visa processing. So you can still apply for E2s and you can still try to make expedited appointments, but it's very backlogged and very complicated right now to actually get an appointment. I have here the link, and I know we're going to share this presentation at the end for the actual requirements for the COVID test. So once you've gotten your national interest exception, then you can go to this link or you can Google it and you'll see what those requirements are. So just a few take-home lessons in conclusion. There's a long road ahead for change. I think that now we've shifted from policies and changes in the way that the law is applied based on politics, which was under the Trump administration, which was essentially to derail or deter immigration as much as possible, to a COVID-based and a health-based policy. So there's no way to estimate when these things will go into effect, but I think that they're making their best efforts they can. And I'm hopeful that by the middle of this year that you will see full processing of embassy petitions. So expect backlogs on visa processing and plan accordingly. Use the national interest exception as a tool. We've used it many times. I think it's fantastic. I didn't even expect it to exist, and I'm so happy that it does, because it has allowed a lot of my Danish clients to continue to operate and to bring people back that are needed. Do not forget that USCIS has not ceased to function. And so if you're in the US or you have employees in the US, and you need to make sure that you're extending your status and protecting that, because once you've lost that, it's very difficult to be able to correct it or to come back into the United States. So do not leave the US without a plan. Don't improvise. If you're planning US market entry, you can do this as you can do the building blocks and setup of your new entities via ESTA and the B1 visa. So even if you have a US entity set up, you are allowed to do all things that have to do with setting up an entity, so then you can apply for an L1 or an E2 visa. And you can utilize the national interest exception to do this. So I highly recommend that you don't have to stop. If you get an exception and you have ESTA or B1, you can continue to build your US business to the point where you're then ready to apply for the visa that you need to run the company. I always say this in my other presentations, people have seen this, always apply for E2 if you qualify. L1 is an option, but right now there's a stop on issuance of L1s. There's a backlog on the appointments for them. And you also lose times. This is important. So if you apply for what's called the new office L1, you get 1 year and you have a termination date or an end date that's fixed. So if it takes 7 months to get your visa, you've lost 7 months of that 12 months from your L. Whereas if you apply for an E2, not only can you get 5 years, but you get it from the time you receive the visa going forward 5 years. So it's always better to apply for E2 if possible. If you're aiming to hire an H-1B employee, which could start next month, then make sure that they're staying in the US if they're here as a change of status. Obviously, plan ahead and consult with an expert. And most importantly, keep the faith. Better times are ahead, and the US will be fully open for business soon. That's it. Thank you. And now we'll take some questions.
Okay. Steve, thank you very much. That was very helpful and informative. We actually have a bunch of questions, so I'm not sure we'll be able to get through all of them. But as we said earlier, if we don't get to it, Steve is happy to do a short consult with you after this webinar. And Steve, you may have covered some of these, but I'm going to just tick through the list here.
Yeah. I'll give some general answers, and then if people need more in-depth analysis on their specific cases, I can set that up with them.
Okay. This one, what would you suggest if a Danish person were to start a US corporation in terms of visa? Would the E2 investor visa, which according to Google is around $100,000, be the only solution?
Well, I don't know if it's the only solution, but it's definitely the best solution. I even just mentioned always E2 over L1, but one of the great advantages of E2 is that you're not required to have a foreign entity at all like L1. You can do a completely brand new startup. So you can set up a brand new business, you can move your business to the US, you can buy a franchise. There's no limits on the vertical or the kind of business. And in terms of the actual investment amount, you just have to pass what's called the substantiality test, which means you've invested enough in the business to cover all operating costs for the first full year, including at least 2 jobs that you're going to create, because it's all about job creation. On top of that, you can get 5 years because Denmark has favored nation status and can get a full 5 years. Your Swedish neighbors only get 2 years, for example. So it's great to be Dane, to be a Dane and to apply for E2. And 100,000 is a good number if you can justify why that's necessary, and then that's enough to cover those operating costs.
Okay, thanks, Steve. And next, I think you sort of touched on this already, but response times of the USCIS for work permits in particular have been all over the place for a couple of years under the Trump administration. Do you expect these response times to improve with the Biden administration's renewed focus?
Yes, and I guess that touches on my last point. I am hopeful. They used to take about 3 months, and now the ballpark figure was somewhere around 6 months. And if things were working efficiently, and that's very frustrating. So the rule of thumb is to apply as soon as you can for them. As soon as you're eligible to apply, you want to apply. So, for example, you're the spouse of an L1 and you have an L2 visa. You want to apply as soon as you enter the U.S. Make sure that that's part of your strategy. But you have to keep in mind that this will take a while for these backlogs to be unjammed and for things to start functioning normally. I would say for the next 6 months at least, it's going to be more of the same.
Okay, here's a couple questions about children, spouses and children. Can you bring your spouse and children if you are approved under NIE?
Yes, great question. So you want to apply together. So you apply as a family unit, and what you do is you provide all the documentation that I already suggested, and you make the economic arguments, and you get the letters from the company in the US and perhaps company overseas if that applies. And then you want to show proof of your relationship. So your marriage certificate, birth certificates, anything that shows that you're clearly tied together. And obviously if you have visas together, like L1, L2, you want to include a copy of all those as well and make sure they're all part of the same application. So you should be approved as a family union.
Okay, next, Steve, we are completing an L1 application for an employee in Denmark. Knowing the time frame is unknown, is it possible to bring the employee to the US via an ESTA? The employee is a key individual for the US IT infrastructure due to his experience in the DK in Denmark.
Yeah, and we could probably go into that more detail offline, but I actually touched on that point, which is it's been a great tool for my clients to use NIE, make sure that you're doing it as a representative of your foreign employer, and then you have a letter from the US company saying that you're coming to consult on something specific. You don't want to say that you're going to be working for the US company, because then obviously you're not authorized to do that. That could get in the way of a potential L1 petition. So you want to make sure that the language is very safe and that you're clearly doing it in representation of the foreign company.
Okay, there's a bunch of questions about time frame and interviews. I think you touched on it, but somebody asked, I have an H3 petition and an interview at the embassy on April 7th. Should I expect that to be postponed or canceled?
If you had asked me that question before February 11th, I would have said it would probably be kept. Now that the embassy has reevaluated its priorities and is restricting interviews only to F1s for the time being, it really depends on the whatever the policies are in Denmark and if those are lifted or not, because that's the justification the US Embassy is using. The problem with H3 obviously too is that you can only do it, you have a specific end date. And so the problem with that is that you're going to lose that upfront time the longer you have to wait. So what I might not have said in my presentation is if you're projecting forward, let's say you want to submit an L1, you want to put a much later start date, like the middle of the year if possible, so you don't lose the back end of that time when they get their visa.
Okay, some of these are fairly detailed questions, Steve. So those might be better
Offline.
for private consultation. Do you know if the NIE is in place for entering Canada as well?
Yeah, Canada has its own rules and regulations, so I'm not sure, to be honest with you. I can't speak on. I know that they're much more restrictive than the US is, but I don't know if they have something like that or not.
How can children, young adults living in Denmark or Germany visit their parents in the US? Do they need an L1?
That really, I think we would have to go offline for that too. I think that depends on who their parents are and what status they have. You know, if they're the children of, let's say you're a child and your father gets an L1 petition approved and he quickly goes to the US, maybe before COVID, obviously, and you stay, you can do what's called following to join. So you could apply for a visa as a family member. The problem is you're not going to get that national interest exception unless you have the visa. So that could be complicated, but it's really case by case.
Okay, I think, Steve, you've touched on this one, but I'll ask it because there might be some other things you want to say about it. Are visa interviews currently available and being scheduled at the U.S. Embassy in Denmark? We know you talked about that. We had a difficult time obtaining interviews in 2020. We are a member of the U.S. Chamber of Commerce, and therefore, because of the NAM lawsuit, exempt from presidential. Yeah.
So I received this question this morning, and I added that slide actually because of that question, because it's not something that generally comes up. So the answer is you should qualify for the exemption. The problem is that the only appointments that you could get right now are expedited appointments, and those are based on humanitarian or medical reasons. So I don't see how, unless it applies to your specific case, how that would apply. And so I think that you have to wait now. You certainly should make an attempt to get an expedited appointment, but if that doesn't work, then you just have to wait your turn.
Here's one, Steve, that I think you addressed earlier in your presentation about expiration, but my L1 expires in May. Can I stay in the US while waiting for extension approval?
Yes, so the good news is it sounds like you've already submitted an extension request, and that's very important because you need to do that before that expiration date. And make sure that that is in sync with your I-94, like I mentioned. Check your I-94 and what that authorized date until date is, and make sure that you're applying before then. Once that's in process, you can remain in the US legally. I suggest you apply with premium processing, because if you don't, once that date is passed, if your petition is still pending, you have legal status, you're pending an extension, but you're not supposed to be working. You'd have to be taken off the payroll. So make sure you're applying with premium processing.
This one looks like it's a question about student visas. I'm in the process of training myself as an event coordinator, need a year on my education. I've been allowed to work abroad and have to go to school in Denmark for 12 weeks. I have to fly back and forth. Which visa do I need? I think they're trying to get at what, is that a student visa question?
It might be, but I think we should probably deal with that offline. So, you can write me and we'll set up a 15-minute talk to figure it out, because it's not clear with the question.
Steve, you might want to, while we have this group and before we forget, if you want to, I don't know if you want to provide your email address.
I'll share my screen again, and I'll just show the last page. My email is right there in the middle of the screen. So anyone, I think you can also contact the chamber, but my email is right there in the middle of the screen. If you want to set up a free 15-minute consultation, I'm happy to do that. So I'll just leave it up for a minute, Seth. If there are any more questions, I can continue.
Yeah, I'm trying to sift through here. There's a bunch. And again, some of these may overlap, and including overlap with some of your information already presented. If a Danish company has E2 visa due to a new US branch, when can the Danish headquarters move an employee to the US using E2 if headquarters starts the process today? Well, that's another timing question.
Yeah, it's a timing question. The most important thing I always tell people with E2s, and I've presented many of them at the US Embassy in Copenhagen, is to make sure that you're doing them really well. They're very picky. They say specifically, we don't want any extraneous information, pretty pages and overly long business plans. You only have 100 pages you can use for your petition. So the most important thing is to prepare it really well. In the meantime, you may be able to get an exception to travel to the US, like I said, under ESTA, to continue the setup of your business while your petition is pending. So they're accepting the petitions, but the dates where you would be able to use it, I would say if you use the NIE and ESTA You could probably go in and out twice and spend up to 6 months in the US. That would give you enough time to get your interview for your E2. Most important thing though with timing is making sure that you present a really strong petition.
Okay, we have a couple more here. This one sounds has a lot of facts, so it's likely an offline conversation, but I'll read it to you. It's almost like a law school exam question. One of our project managers is a Russian citizen and urgently needed in the US. His L1 had expired, but we have received an approval notice via USCIS. However, it is not possible for us to obtain an expedited appointment for him in the consulate in Moscow or Copenhagen.
Right.
We are now applying for a B visa using after sales purpose, but the expedited appointment was already denied in Copenhagen. Could you recommend which consulate we should try to obtain an expedited appointment? Okay, that's a mouthful.
Yeah, that's hard. I'll just give a general answer, which is you don't want to do what's called forum shopping. If you show up at a if your client goes to Georgia to Tbilisi at the US Embassy and decides to apply, they're going to say, you have no ties to this country. You shouldn't be applying here. And they may get denied. And once you have a denied application, your chances of getting it anywhere are much lower. So you have to weigh your pluses and minuses here. What's the cost? What's the risk of doing it? And I'm happy to talk about it offline, but you want to be careful when you forum shop. I think it's going to be hard to get an expedited appointment anywhere right now.
Okay, I think we've covered most of the questions. Again, if there are additional questions or specific circumstances, Steve has generously offered his time. He's happy to do a short free consult. So you should certainly feel free to reach out to him after this event. I'd like to thank everyone. I'd like to thank Steve in particular for being a great host, and Kristen Schoenberg as well for being the master of technology. I don't know what we would do without you. And thank you everyone for joining us. And as a reminder, we look forward to seeing you at our next event in March, which should be a lot of fun. It'll be a wine tasting for a winemaker in the Finger Lakes, Ravines Wine, and the winemaker is actually a Denmark-born individual and somehow wound up in the Finger Lakes making wine. So it's an interesting story, and he makes some great wine. So we look forward to seeing you at our next event. Thanks, everyone.
Thank you.